Welcome back to A View from Legal Street. Help us help you get paid. Our short series of videos with real-world tips and tricks to help healthcare providers to maximize their reimbursement from commercial insurance companies so you can get paid for the valuable services you render. I'm Zach Rothenberg, co-chair of the litigation practice group here at Nelson Hardiman in Los Angeles. Nelson Hardiman is 25 lawyers dedicated to representing healthcare providers and life sciences entrepreneurs. Look, I've said it before, and I'll say it again, medical records are the number one most frequent reason that insurance companies use to deny claims. Medical records are at the heart of each step of the reimbursement process, from making an initial claim to an appeal, and ultimately, in a worst-case scenario, in a lawsuit. We could spend all day talking about medical records, but today I want to focus on one narrow issue. In the event you have to go to court to prove your claim that you are owed money, how do you make sure that your medical records are admissible so that a judge or a jury can see them and factor them into their decision? And we need to get a little bit into the legal weeds here, so bear with me. We're going to be talking about the Hearsay Rule, and I'm sure some of you have heard of that, but let's talk about what it really is. It is a rule that says that an out-of-court statement is inadmissible for the truth of the matter asserted. And I'll give you an example here because that's not terribly clear. I sell a car to my partner, John, and I say, John, this car runs like new, you should buy it. John believes me and buys it. But the next day realizes the car really doesn't run so well. Takes it to a mechanic, and the mechanic says, oh boy, you bought a lemon. John gets upset, rightly so, and sues me. And when we go to trial, John comes into court to testify and says, Your Honor, I took this car to a mechanic, and here's what the mechanic said about the car. And right there, I would object on the basis of hearsay because John's about to talk about what the mechanic said, an out-of-court statement that would be used to prove the truth of the matter asserted, the quality of the car. And that's inadmissible. And the reason here is important. I should have the opportunity, if we're going to talk about what the mechanic said, to cross-examine the mechanic. I should be able to say, Mr. Mechanic, what exactly was so bad about the car? What did you do to test it? And do you have any biases, for example? Is John your brother? Did John pay you to testify? These are all things I should have the opportunity to cross-examine the mechanic about, but if he's not actually testifying in court, I can't do that. And the same applies, by the way, to a writing. So if John brought in a written statement from the mechanic that said the car was a junk, that's still hearsay because I wouldn't have the opportunity to cross-examine the mechanic. Now, if the mechanic came into court and testified, that's fine. But if it's out of court, it's inadmissible because I wouldn't have the opportunity to cross-examine. So hopefully, right now, you're thinking, yikes, what about my medical records? They're an out-of-court statement, and they would be used to prove the truth of the matter asserted in terms of the healthcare treatment I provided and what I want to be paid for. Well, the answer, fortunately, is that no, it's probably not a hearsay issue, and that's because there are a number of important exceptions to the hearsay rule. And the one we're talking about today is the business records exception. If something qualifies as a quote-unquote business record, it can be excused from the hearsay rule and be admitted into court. Now, that's a long wind-up, but the important thing here is how do I make sure that my medical records qualify as a quote-unquote business record for purposes of hearsay? And there are 5 things you need to know. Number 1, it must be a writing made in the regular course of business. So this means you have to have a practice and a policy and procedure for exactly how medical records are created in your business. Who can enter them, how they're entered, when they're entered, and it must be standardized across your entire business. And the point here is that it can't be something special, some special document that you created just when a dispute arose or just before trial. It has to be something that you do regularly and systematically, just as the ordinary part of your business. Number 2, it must be a writing that was made at or near the time of the act being recorded. So if you're going to make a note about a procedure you performed at 3:30 p.m. on a Tuesday, it's best if you can enter that note at 3:35 p.m. on Tuesday or as soon as reasonably possible after the act that you're entering. And the purpose there is so that you can prove that the notes you're making in the medical record are likely to be accurate. It's not something you waited months and months to enter into the chart because then you may have forgotten and it may not be as accurate as possible. Number 3, you're going to need to have a witness come into court to testify about exactly how medical records are entered. And that's another reason why it needs to be systematic across your entire business, so that one witness can come in and testify, this is how we maintain and create our medical records at this business. Anybody who enters into the chart does it in the same exact way. So it has to be systematic. Number 4, the writing must appear trustworthy based on the source and method of preparation. This means is that your notes should be clear about who is entering the particular note, when it's being entered, and again, it should be close in proximity to the event being recorded. So you'll want to have a space in the medical record that identifies clearly who is making the note and when the note is being made. And number 5, the writing must be a true copy as kept in the usual course of business. And this means your medical records must be maintained safely so that they cannot be manipulated or changed or beefed up at the time of trial so that they sound extra good to the jury. You want to make sure that perhaps they're password protected, or in some other way you are ensuring that the medical records are entered at or near the time of the act and that they're not being changed afterwards, to make sure that they are secure. And if you follow those things, you should be pretty safe in that your medical records will be treated as a business record, will be an exception from the hearsay rule, and you'll be able to enter them into evidence at trial so that the judge or the jury can review them and ultimately decide in your favor. Thanks for joining me. We will see you next time.